We're taking you to Parliament right now because the minority has been addressing a news conference responding directly to the Attorney General, who spoke a lot earlier in the day today about the discontinuation of that suit against Dr. Kwabena Duffuor and some 7 others. Let's take you to Parliament right now, where Kwame Enyimadu entry addressed the media.
Kwabena Duffuor and 7 others calls for serious scrutiny having regard to the entire circumstances of the said case, which we set to outline in this press conference for the good people of Ghana to better appreciate its unacceptable repercussions on the country. Ladies and gentlemen of the press, to better understand the case under reference, permit the minority to make reference to the press release dated 22nd of July 2025 that has emanated from the Attorney General as reproduced here below. I'm sure most of you had read it, but it started by saying that the Attorney General has, on that day, which was 22nd, entered a nolle prosequi in the case of the Republic versus Kwabena Duffuor and 7 others. While the exercise of this prosecution, blah, 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 because you have it, ladies and gentlemen, I will not bore you. So when you are done and people don't have it, I can easily give you a copy. The press release arose against the following background. Unibank was one of the financial institutions that was affected by the financial sector cleanup by the Bank of Ghana. Thus, following the banking cleanup exercise, the Bank of Ghana detected that a whooping amount of depositors' funds totaling 5.7 billion had become due, but the said amount was not available at all material times for payment accordingly. Subsequently, investigations revealed that Dr. Duffuor and co. transferred the said funds to some related and connected businesses, and that in the end, Unibank was rendered insolvent. It is instructive to note that these criminal activities were uncovered after the revocation of license of Unibank and the subsequent appointment of a receiver by the Bank of Ghana. Consequently, the charges of fraudulent breach of trust, money laundering, among others, were brought against Dr. Kwabena Duffuor and some 7 others. I'll say 7 now because you know what happened. There were 8 others. There were 9 accused persons. But when this Attorney General assumed office, he freed 1 Dr. Esiama, and that is why they have it as 7 others. So I'll keep it as Dr. Duffuor and 7 others. Ladies and gentlemen, in view of the above, Ghanaians, including us, the minority in Parliament, have since been wondering the legal basis for the entry of a nolle prosequi in the suit under reference by the learned Attorney General, and therefore we deem it appropriate to raise questions produced below for the Attorney General to answer for the benefit of the good people of Ghana. Number 1, has Dr. Dominic Akuritenga Ayine in the past acted for Dr. Kwabena Duffuor and Unibank? In the case of the Republic versus Kwabena Duffuor and 7 others, is Dr. Ayine now the Attorney General of the Republic of Ghana? The deputy referred to him as the Attorney General, and today he has granted a press conference acknowledging that he gave out the press release and he tries to justify why he entered the nolle prosequi. Ghanaians would want the Attorney General to explain to us in full the extent of conflict of interest using Dominic Ayine as defense counsel and Dominic Ayine as the Attorney General. This he failed in the press conference to tell Ghanaians that he had acted for Unibank and that he had acted for Dr. Kwabena Duffuor. So I think he owes us as a country a duty to explain to us why and the extent of this conflict of interest. The next question: does the Attorney General have the right, in law they say so motu, to free offenders at his own discretion, or is he obliged by law to prosecute and punish offenders in the country, especially in cases involving grave financial crimes against the state? Is he not legally and constitutionally obliged to ensure prosecution and punishment of those who commit economic crimes? What happened? What prevented the Attorney General from continuing with the prosecution of the Republic versus Kwabena Duffuor and 7 others, especially when the prosecution had far advanced its case before the court? I am told that they had called even the second prosecution witness. But today, the learned Attorney General tells us that on his own, he comes out and says that he negotiated with the parties without any court's involvement, and he intends to free. He has already entered a nolle prosequi, so he had freed them. The next question, or question 3, that I may want to ask: transparency, as indicated in the press release, demands the learned Attorney General to explain to Ghanaians the principle of 60-40. Ladies and gentlemen of the press, once a nolle prosequi is entered by the Attorney General or the prosecution, we need not find out, and we don't need to find out questions. But he chooses to, if you read the press release, he chooses to justify why he had done that in the name of transparency. And that's why I say that transparency, as he had indicated in the press release, demands that he, the learned Attorney General, would explain to Ghanaians the principle of 60-40. If you're talking about 5.7 billion cedis and you tell us that you have retrieved 800,000 cedis, how can you say that that represents 60,000? And at any rate, is it a new policy directive, or when did this come into Ghana? When was this introduced into our criminal jurisprudence? What happens to the remaining 40%? To him, the Attorney General, today we heard him say that the 60-40, we can forget about the 40%, because he uses the proverbial theft of six goals, that if 2 or 4 are recovered, then he can allow the 2 to go off, meaning that the 40%, what the Attorney General in his jurisprudence is telling Ghanaians, that he would let go the 40%. That means the 40% should go with. The press release makes reference to 60% recovery threshold as a benchmark for reconsidering prosecutions. When was this policy introduced, and under what legal authority? Was this benchmark made public or debated in Parliament? Was it quietly introduced post-2024 to lower the standards of accountability? For a case involving 5.7 billion, can the Attorney General confirm that 1 billion has indeed been recovered? and provide documented proof of the recovery? It is strange that the Attorney General is insisting that the amount of 800 million cedis recovered from Dr. Duffuor constitute 60%. How did the Attorney General review the amount from the 5.7 billion to 1.2 billion by a mere administrative fiat? The best we heard from him today is to make arrangements for the amount to be paid into public fund. One would have thought that he would wait until the amount, the recovery that he's talking about, would have been paid into the coffers of the state before thinking of nolle prosequi. Did the Attorney General consider Section 35 of the Courts Act, Act 459, in coming out with the 60-40 threshold? For the avoidance of doubt, Section 35 of Act 459 states, and for the lack of time, let me paraphrase, that if you want to make any restitution in such cases, you consider Section 35, which says that a person may plead to a lesser amount, and then you can then enter a nolle prosequi or file anything for the courts to consider. And if the person fails to do that, then the person could be punished. When I finish, I can give you a copy of what I'm holding, and then you can have the full text of Section 35 of the Courts Act. Why did the Attorney General turn a blind eye on the above institutional provision? Why would the Attorney General also look at the principle of the plea bargaining agreement? Under our section, that is the Criminal Procedure Act, Act 30, as amended by Act 1079, and I have a copy of the Plea Bargaining Act as amended. The Attorney General is telling us today that he did not even look at the Plea Bargaining Act. He didn't look at the Courts Act. He didn't look at the Plea Bargaining Act. The process was not supervised by any court. And what he is telling us is that he himself, on his own, so motu, got the parties and negotiated with them. Where did he get the figures from? When the prosecution had already started this prosecution, and I have the facts as presented by the prosecution, and those who are interested, I can give you copies, you make copies of that. And when we had done this, why did the Attorney General ignore this, and why didn't he tell us anything from this? Why was the accused person not convicted, even when he agreed to pay 60% in line with plea bargain agreement under Section 35 or under the plea bargaining agreement or under Section 35 of the Courts Act? For plea bargain to be accepted by the court, there are a lot of options opened to the parties, including conviction. However, any such process must be supervised by the court. In the learned Attorney General's nolle prosequi, he just enters. Nobody would have thought that we would ask him questions. But because he chooses to say that he wants to be transparent, we want him to be more transparent and answer the questions that we are asking him. So how the Attorney General allowed the accused person to walk free without a conviction and without supervision of the process by the court, that definitely cannot be under a plea bargain agreement, as he had himself said. And if it is not a plea bargain agreement, and it also doesn't come under Section 35 of the Courts Act, where did he get the 60%, and how much has he collected? Today he tells us that he's going to make arrangements for the monies that have been collected about 800,000 to be paid into government coffers. The learned Attorney General has obviously forgotten the theories of prosecution and punishment. In fact, if he had thought of it, he would have appreciated that deterrence is one of the theories that we take into consideration in punishing people. Ladies and gentlemen, as we conclude, we would like to take this opportunity to call on all voices of conscience in our society, especially lawyers, judges, civil society, clergy, traditional leaders, and you, the press, to sit down and watch, and not to sit down and watch unconcerned, whilst the Attorney General, trusted with the office responsible to uphold the rule of law, on the contrary, pursue rather a destructive agenda to the detriment of the good people of Ghana. We therefore call upon any interested party, the Parliament of Ghana, particularly its Select Committee on Constitutional and Legal Affairs, to summon the Attorney General to answer these questions publicly. The Legal Council and Bar Association to investigate potential breaches of legal ethics and professional conduct. All patriotic Ghanaians to stand up against what appears to be the erosion of justice and the dangerous politicization of the prosecutorial process. Finally, may this press conference also serve as a formal notice to the Attorney General, Dr. Dominic Ayine, that if his decision is not reversed within a reasonable time, the minority will consider its options of proceeding to court to challenge its decision in its entirety. Let it be known that justice must not only be done, but it must be manifestly seen to be done. Thank you. If there are some questions, I will take it. One of the actions that we heard him this morning speak to the press, and we said twice to answer what he's doing, and we think that he's not doing the right. So once we've come out of this press conference, we have to hold him accountable. We see, he gives an impression that the system that he met is not helping to retrieve monies, and that monies are going to waste. But I will get in the same financial sector crisis, I will cite the case of the Crowell and Associate in Unibank. When the court supervised, the court said that they should pay 1/3, and they paid 90 million cedis upfront before. And when he was not able to pay the rest, the person is convicted and is in jail now. So it's not a matter of saying that I won't put people before jail. There are laws in this country, and deterrence is also right, so that if somebody does the wrong thing, you punish him. We hear the Attorney General also citing the Beige capital issue now as an example, which is a clear indication that he doesn't even plan to take the case further, probably appeal against the decision of the court. It means that he is satisfied. And he also gives an impression that he is not perturbed about financial crimes, and he equates civil actions or civil threshold to criminal threshold, and I think he is wrong.
And so that's Kwame Anyimadu. He is the ranking on the Constitutional, Legal and Parliamentary Affairs Committee of Parliament, addressing the press a lot earlier. Still, that raging debate over the Attorney General's decision to file a nolli prosequi in the case involving the state and the former founder of Unibank, and now a defunct bank, and some 7 others. The Attorney General earlier today sought to provide reasons as to why he decided to discontinue the case. Well, they say that if he wants to be transparent, he should do that fully, and that a failure of him to reverse his decision to file a nolle prosequi will see them go to court, and they are also pushing that the committee will drag the Attorney General before Parliament or before the committee and the House to answer questions where they can ask a bit more of him in these explanations. That's the latest that's been coming through from the quarters of Parliament. We'll continue to monitor this and bring you details and reactions a lot later on News 360. Stay with us. This is TV3.